Assalamu alaikum, Your Highness, Your Excellencies, distinguished guests. I'd like to begin by thanking the Saudi Center for Commercial Arbitration, their board of directors and their officers for the kind and generous invitation to participate and to speak at this very important conference. In my 12 or 15 minutes, I want to do 4 things. First of all, I'd like to sketch a brief history of investor-state dispute settlement. I'd then like to look at the existing balance between the interests of investors on the one hand and states on the other. I'd then like to look at some of the problems of the existing system. And finally, I'd like to ask what can or should be done looking to the future. Turning to the first element, a brief history of investor-state dispute settlement. Until the 1990s, there was very little protection for foreign investors when they made an investment in another state. That was placing a fetter on the development, on economic development. So in the 1990s, BITs, or bilateral investment treaties, emerged, and they emerged as a very strong trend during that decade. They emerged because capital exporting countries wanted protection for their investors, and capital importing countries were looking for foreign investment for economic development. So about 500 bilateral investment treaties were concluded during the 1990s. Since then, over 3,300 bilateral investment treaties had been concluded by the end of 2016, which is the most recent date that I have a figure for. So, in essence, as has been described by another commentator, what was created was a de facto global regime. The key element of that global regime was that BITs, bilateral investment treaties, enabled investors to bring claims in arbitration for damages if the host state applied sovereign regulatory measures which were incompatible with the BIT, the treaty. Of course, there is an inevitable time lapse between a treaty being entered into, investment being made, and disputes, and those disputes in turn proceeding to arbitrations. So that in the early 1990s, there were really very few ISDIS cases, investor-state dispute settlement cases. But as of the end of 2017, there were 855 known treaty-based investor-state arbitrations. And the reason for that enormous development was twofold. Essentially, sovereign regulatory measures became more pervasive, but also there was what I've termed an expansionist approach of ISDS arbitral tribunals. Before we look in that in a little bit more detail, it might be helpful just to look at the geographic spread of the cases that I've mentioned. In the Central and East European, Central Asian area of the world, that accounts for 26%, just over a quarter of the cases. South America, just under a quarter. Sub-Saharan Africa 15%, and the MENA region 11%, with no other geographic region exceeding 10%. So what one can see from this list is that the emerging world, very often nations which were poorer than the richer nations, found themselves confronted by claims for very substantial damages and very substantial costs in the process of resolving these disputes. The result, almost inevitably, was what happened, namely that there was a backlash. States considered that investor-state dispute settlement regime was too investor-friendly, and there was a view that state-investor balance needed recalibration. Turning to the second element of what I'm talking about today, namely, what was the balance, what were the mechanisms, the checks, the balances between investors and state? Let me take the doctrine of the fork in the road as an example. The fork in the road essentially said that if an investor chooses to litigate a dispute in the domestic courts of the host state, then it loses the right to arbitrate the dispute under a bilateral investment treaty or an international investment agreement. Now, of course, that sounds very sensible. You have literally the fork in the road. You choose one route, you're precluded from taking the other route, at least in theory. But the question really is, how have these limiting practices, or limiting principles, been applied in practice? Looking in context, there are perhaps 4 types of limits that states have tried to impose. They've tried to impose scope limitations on bits by saying that the bit will only cover treaty claims and not anything else. States have tried to apply carve-outs from the bit and therefore limit the scope of the bit. They've also said, well, we need to have a cooling off period, a waiting period, so a time limitation, putting in time in the hope that matters can be negotiated. Choice limitations, this is the fork in the road. You choose one route, you're precluded from going down another route. There have also been sequencing limitations, a requirement to exhaust local or domestic remedies. On the other side of the equation, however, investors and, in large part, arbitral tribunals have tried and sought to expand the scope of investor-state dispute settlement. So in terms of expanding the scope, what is an investment? It's not defined in the ICSID Convention, and arbitral tribunals have given a very wide meaning to the word. There are vague or imprecise concepts, fair and equitable treatment, full protection and security. Even expropriation, which may seem to be relatively precise, does taxation amount to expropriation or not? There's then been the use of most favored nation clauses. In other words, one country has to be treated in no lesser way than the relationship between the host state and any other country. So you can search for a more preferable regime in other treaties. The use of umbrella clauses. As far as time, it's been held that waiting periods are not mandatory or jurisdictional. They are instead merely procedural and directory. In terms of the fork in the road, arbitral tribunals and investors have said there has to be identicality, identicality of party, identicality of claims, and identicality of issues. And that can severely limit the scope of the fork in the road choice. treaty claims, they can be seen as jurisdictionally and juridically different. So in other words, even though you have got claims in another forum, you can still bring your treaty claim. And sequencing claims, there's been a very indulgent view taken of what amounts to exhaustion of local remedies. Let me move to the third point, which is Let me move to the third point, which is some of the problems. First and foremost, one must ask what is investor-state dispute resolution? Some have termed it privatized governance. So is there a question mark even over the legitimacy of the decision-making powers of ISDS tribunals? Is there a need for a proportionality framework? And can tribunals create a global administrative governance standard through the publication of awards? Can that publication create a global consistency? All of these issues fall within privatized governance. There's then the vagueness of the language that I've already referred to. What is and is not fair and equitable treatment? So you have uncertainty of scope, and up to a quarter of claims are rejected through declining of jurisdiction, a trend which has been mildly increasing. There is also the problem of inconsistent decisions, the absence of any jurisprudence constante with no appeal process. Complaints about weak reasoning in awards, failure to grapple with the complexities, and little more than, well, I'll know it when I see it, in terms of the rationale. Is there a chilling effect on sovereign policy space? What that should be properly the domain of a sovereign nation. A country in financial crisis may see necessity in one way. Subsequently, years later, a tribunal may see those same circumstances in different lights. There have even been examples of tribunals second-guessing Supreme Courts, and India felt very strongly about that and has indeed adapted its own bilateral investment treaties in the light of its own experience. It's also important to ask, is there a structural bias? Is this a North construct imposed on South states? And there's a growing feeling that investment arbitration, or investments, extend beyond pure business and finance to include environmental considerations, public health considerations, labor and social standards. How are all these to be accommodated within the ISDS regime? There have also been questions over independence and impartiality of arbitrators. Do parties appoint a sympathetic arbitrator? Is there a conflict of interest between someone who is an arbitrator in one case and counsel in another? And what about repeat appointments by states, by the same law firms, repeat appointments to determine similar issues? It might be of interest that literally last week at the International Bar Association conference, a draft report on consistency, efficiency, and transparency in investment treaty arbitration was published. As you can see, I have a copy, and I plan to make a copy available to the Saudi Centre. Let me skip the final slide on this section and ask whether we're at a turning point with regard to investor-state arbitration. Is there a systemic tension in the system? Is there a systemic imbalance in favor of investors? Are there new system dynamics? And is there a need for independent, reasoned review? Is there a need for an appeal mechanism? Is there a need for a permanent international investment court? In summary, we are perhaps at our own fork in the road. Is investor-state dispute settlement arbitration fit for the purpose? Do we need a court? Should we be considering investor-state mediation? But at the end of the day, are all of these possibilities in search of the same goal? As I say at the end of this slide, it may be that a broader global shift is underway that could lead to new standards of foreign investment regulation. Thank you indeed for listening, and I'll be happy to take questions in due course.
Thank you.